Hello, I hope this is set on public now because we was just talking to nobody just a moment ago. Hello, welcome to this special edition of the Education Magazine. I hope that you can now see us live. We had a technical problem 5 minutes ago, so I do apologise for that. But everything should be working now, operating, I hope, as normal. So with me is Charmaine. Charmaine, how lovely to see you. You're from our education department. Nice to see you.
Nice to see you too. And lovely to be invited to join this panel.
Good. Lovely to see you, Charmaine. We also have guests who are online, including, of course, some parents who are going to present some questions this afternoon. And we also have, as part of our specialist panel, the very famous Chris McFarland, who you all probably know very well. Chris, how nice to see you. Good afternoon.
Nice to see you as well, Mike. It's good to be here. Thank you for inviting me.
Yeah, and we also have with us the wonderful David Lawson, who is a specialist barrister, having done lots of very important cases in this particular area, including community care and public law. David, and he's from Sergeant's Inn in London. David, lovely to see you this afternoon.
And you, Mike. Great to see you.
And you're impressed with our studio here?
I am. Yeah, very swish.
Well, I'm glad you are. We do try our best, David. And also, you've seen her many times before because she's come on these podcasts before and talked about FII and all sorts of other matters pertaining to social care. Kathy Long, who is an excellent social worker practitioner, brilliant expert witness in tribunal and in courts. Kathy, how wonderful it is to have you here this afternoon. Thanks for joining us.
Yeah, good afternoon, everybody. Good afternoon, Mike. And I'm really happy to be here. Thank you.
And we've gone back a long way, Kathy, haven't we? I remember the early days when you first started doing this.
Yeah, I first started working, with you on some of the cases that came up in 2010.
Oh, my Lord. Yeah, there we go. 14 years.
A bit scary, isn't it?
I know. Well, I mean, this afternoon is going to be quite different than normal because we're going to have, as I say, some guests who are going to present some questions. And lots of questions have been presented on my Facebook page in the past. And we have collected those questions and looked at which ones are the most popular. Charmaine's done that job. Charmaine, what a good job you've done.
Thank you very much, Mike.
And the first question comes from Anna Chilcott, who says, how do we, as parent carers, hold local authorities to account for their constant and repeated failures to adhere to timeframes, court orders, and the law? She says, I know the answer in some respects is by following the complaints or appeal process or going to the Ombudsman, but none of these processes actually end up in justice for her failed family. That's how she put it. So how do you get a local authority to comply with, timeframes, court orders?
I mean, for the starting point, what Anna has listed out is quite correct, where you have to go through the local authority complaint process. And once that's been exhausted, then you go to the legal ombudsman. Although I do appreciate that a financial compensation could be awarded, but I do understand that it might not truly reflect the losses that has suffered. It's also important to add that pressure onto the local authority persistently and seek legal advice where is possible. And judicial review is where we need to go ahead, to be honest, to have that enforcement against the local authority to ensure that they are complying with the statutory timeframe or other breaches that of their duties. But judicial review wise, we need to assess the child's kind of eligibility and then go from there.
Well, judicial review is a process whereby the courts can supervise the actions or inactions of the local authority. David, judicial review is a useful tool for these cases, aren't they? Isn't it?
Yes, it is, Mike. I was just thinking about what the question of if a local authority, Anna says, is ignoring the situation she's in and even the processes she starts. I mean, there is ultimately there a process of ratcheting up, just a little bit step by step onto the next stage, but it can take it can take a long time. Lawyers get used to different timescales than many people. I was having a conversation with someone yesterday and saying, a year is quite quick, and of course, a year may be a quick way to go from the start of a process right to the end with enforcement, but it feels terribly long for the people in it. And the courts have picked up on that, and the underlying principles are that things need to be done quickly. And there are cases saying that. Was your firm, Mike, in the Devon case about timetables?
No, that wasn't my case.
Okay. That's so many are.
Not that one.
So that's a case where the question of timetables in the special educational needs system went to the Court of Appeal for various procedural reasons, and they said that a striking aspect of the system was that there are short timescales for each individual step, and that those time structures can't really be removed, that they apply pretty much regardless, and that the aim of the SEN regulations is to ascertain speedily the way of meeting the child's needs. So there's pretty high authority saying things should be done quickly. I suppose because there's quite a lot of steps on the route, and in each case, organisations and parents have many days in which to do things. That adds up when both sides are doing things sequentially, one after the other. It adds up to months of time to get things done. Generally, if people really do ignore things, the system ends up by dealing with that. But of course, I think that the system recognises, the cases recognise that just that wait to get it dealt with itself is quite burdensome.
Well, I think what Anna's really saying is that the timeframes are not being adhered to, and court orders even, she says, are not being adhered to. So, and she's saying even the law is not being adhered to. So it's quite a mix of things that poor, bless her, Anna has experienced. Presumably, if a local authority is not complying with the timeframes properly, I would be forcing them through judicial review. Mm-hmm. And if they're not complying with court orders, that could be contempt of court. So I'd be going back to the court and seeking an enforcement in those circumstances. But what I find quite frustrating, I mean, Chris, you probably have seen this too, you experienced this, where Anna says, well, the law is also often being broken. And so she's thinking, well, how do you make or get a local authority to comply with the law in the processes that lead up to the decisions that then are ultimately challenged in the tribunal? So, in other words, the tribunal won't resolve the question of the lawfulness of the local authority thinking, but it might resolve only the question about what should go into the plan, into Anna's EHCP. But what do you do, Chris, in circumstances where the decision-making in the processes leading up to that decision that you ultimately take to tribunal, what do you do about it then? Chris?
Well, I think that as we've talked about, judicial review is the process of that enforcement. It's the way that you can get interim provision, if there's provision already in a plan, that even though you're challenging it, you still want it in place as an interim measure whilst you maybe go for something that you think is more suitable. Again, that is the route. I think the difficulty with that route of enforcement, I think one of the frustrations that I think Anna is quite understandably expressing is that that in and of itself, both through the fact that it's a very formal legal process with cost consequences, so it is not something that a parent could or really should take themselves because of those risks. Obviously, the ability to get legal aid funding or even the capacity of firms such as ourselves, as you know firsthand, Mike, we are extremely busy at the moment because there is so much non-compliance. It is a terrible situation for parents. But really that is the route. And I think that keeping on pushing that, taking the steps that Anna has has put forward as well, as Charmaine correctly pointed out, the local government ombudsman can sometimes provide compensation for non-compliance with meeting needs. Obviously, it's a human right, the right to education. So, of course, there are these enforcement mechanisms, but I think it goes to the more systematic issues we're having in Senate at the moment, which I think are motivating many of these questions, again, quite understandably, is that because the system is currently so overloaded, because the judicial system is currently so overloaded, it is taking a long time for parents to get those outcomes, even through judicial review. And that means that all that while it is suffering. But I think the message that Charmaine gave at the start is the correct one, which is, we do appreciate it can be very taxing. I mean, my sister's herself got severe learning difficulties when I was growing up. This was in the 90s in the predecessor system, of seeing firsthand on the family unit the kind of pressure that can provide, not just where things aren't going right, where it's more acute, but even the kind of standardized things such as annual reviews can really be pressurizing to families and affect the whole family unit. So, but keep plugging away, keep writing those letters, keep making those complaints, do seek out legal advice, where those complaints have fallen on deaf ears, because, that is the only way, unfortunately, the system is written to keep local authorities to those standards.
But Anna says that at every turn, there is no real consequence for the local authorities. She says there's no accountability. She says her family is literally falling apart. Kathy, families are frequently experiencing this enormous pressure, particularly when you're dealing with a case of a complex child. And social services should be doing more, shouldn't they? We see very few sensible assessments in an EHCP case these days.
Yeah. I agree. I haven't got the answers because I can't sort of dictate how a local authority behaves. What I do know is that local authorities aren't necessarily doing very thorough assessments. They're for many reasons are not sort of looking holistically at a person's needs if they get an assessment. And then there's been recent publications, sort of statistics about how many cases go to tribunal, and it's a very small percentage that where local authorities, their stance is upheld. And it's a very costly, lengthy process for parents. And then we come to the place where, as we're talking about now, where a judgment's made and the local authority doesn't necessarily deliver what's made. And I think there needs to be a change in the law, as in with social care, the tribunal can make recommendations. It's not enforceable unless a parent chooses to go to judicial review. I think that's the issue. So there's, I haven't got the answers, but I do see what's happening.
And Charmaine, the tribunals are not actually imposing costs orders or any orders or injunction orders, if you like, against local authorities that fail to comply with the system, the process.
No, they aren't. So it's more judicial review where they can do the quash order, mandatory order, etc. Or in a very rare case, do order like damages, but that's in a very rare occasion.
David, what do you say to a parent who says, well, a tribunal system in the current setup, if it can only deal with making amendments to an EHCP, for example, whether there should be a change to the description of need or provision, what do you say to a parent who says, well, actually, that's not really providing any accountability, because for the way in which they've treated this family all the way through the process that might take, a year or so to resolve? How does the law protect those people?
Well, that's a very good question. I was going to ask you the same thing with your experience of tribunals. What do you do when the other party is in breach of orders?
I take judicial review. I do it even in the process of a tribunal. I think that the tribunal, there has to come a time when the tribunals must realise that parents are not getting the resolution of all their issues in their case properly in a process that only looks at whether there should be an amendment to a plan. The enormous failures you take parents who, for example, have got a child who is extremely difficult to manage. The parent in that instance might be providing 24-hour around-the-clock care for that child, and a tribunal that's not going to sit until a year and a half to resolve that case is not going to help the crisis that's confronting the family right then. So I'm afraid that the law is there to protect. And my view is that the procedural rules are there to protect against poor decision making. So they should be held to account for non-compliance. That's my view.
The post-pandemic delay in hearings, I mean, is beyond the peak of the crisis, but it is still. I just issued a case where the hearing's a year from now, and that's a long wait. And it used in the case I was looking at a case the other day just to argue in favour of urgency, and in that case the court, different case, but the Court of Appeal in that case said that it very much regretted it took 6 months to get a tribunal hearing 10 years ago. So
Yeah.
that's very, very regrettable amount of time to wait for a hearing in an area like this. And now I would say a year is pretty standard.
Yeah, exactly right. And that's not resolving. I mean, we also have some guests I know this afternoon who are going to present live questions. I mean, Rosie Thompson is one, a parent who has explained to us that she's part of a rapidly expanding group of special needs parents whose direct payments and respite transport has been stopped by local authorities. I'm not sure if Rosie's available right now. Is Rosie here? So please bring her in. Rosie, one moment. We're just going to bring Rosie in. Rosie, good afternoon. Thanks for joining us. I think you're here, aren't you? No, she's not here. Rosie? The joys of being live. Rosie, no, well, okay, we'll just discuss Rosie's question then. She says, we are a rapidly expanding group of special needs parents whose direct payments and respite transport has been stopped by local authorities who are prioritising financial cuts over needs of our children and families. Despite following process for complaints appeals, none of us are gaining any satisfactory results to date. And we're discovering many breaches in the law regarding how those decisions are being executed. And there seems to be a common thread in how we are being treated by social services. Kathy, you must be experiencing that. You're seeing that.
I jump in. I think Rosie is here.
Rosie's here. Rosie. Hello. Rosie. Oh, I'm so sorry. I just excluded you. I didn't know you were.
It took a bit of time to get on. That's
Rosie, lovely. Well, thank you for joining us this afternoon. I know this is the joys of going live. Sometimes we have technical problems. I was talking for 5 minutes apparently. I wasn't even live, so that's why I came on 5 minutes late. Rosie, well, tell us in your words what your question is.
Basically, my question is, thank you for this opportunity, by the way. Basically, my question is that we're a group of special needs parents that have had our direct payments stopped and our respite transport stopped. We've, as personally, I'm a parent of a 16-year-old who we've had direct payments for 7 years now. He has quite complex needs in terms of sensory, ADHD, autism, and he basically the social worker came and did an assessment and basically said we no longer fit the criteria for direct payments. I'm not the only one. There's a rapidly expanding group of us that are sort of getting nowhere really with our appeals. We're going through all the processes of appeals. We think that the system is not, the independent advisors that are coming to these appeals are actually not very independent because they are basically working for the council. I haven't got to that stage yet personally myself, but there's lots of parents that have actually at those stages. And we just feel that the financial burden of the council is sort of being it's going over the needs of our children.
Prioritising finance above need.
They're not meeting our children's needs because they basically don't have the finances to do this. Basically, I feel that it must be happening all over the place. It's the Bates versus the post office type of situation. We're involving the BBC, we're involving the MPs, but we need to know really. We need some direction. None of us can afford solicitors, in terms of, you know, putting in a sort of a league or sort of thing. But the way they're doing it, there's a lot of it's not being, the procedures and the policies don't seem to be followed. Parents are telling us lots of different things, lots of different ways, not even a report for their children to be told why they're having these.
Well, Rosie, can I just ask a question? I mean, you're saying that there has been an assessment. So presumably, just so I can understand the question, there's been an assessment originally, and that assessment resulted in you having direct payments. And that assessment also resulted in you having transport to and from the respite facility. Is that right?
Yeah, personally, not me for the respite.
Okay,
transport.
but the question is, yeah, and
in terms of the assessment, 7 years ago we had an assessment, and we were given direct payments for my son. A couple of years ago they were increased. We're only sort of talking 3 hours, 5 hours per week. But when he was assessed, when he became 16 and he was assessed again, we were told that we no longer fitted the criteria.
So they revoked the service. The service was revoked, was it?
Yes. So basically, the direct payment is now stopping, and we're in the process of all that happening.
And so presumably, you're not able in that situation, or the person that you're speaking up for, they are unable to make use of the respite facility because of the transport being excluded from the picture. Is that right?
That's right. And they haven't even had reasons given to them for why they have had their respite transport stopped. They've basically just been told that it's stopping. There's been no reason. The only thing that's been given as a reason is finances, basically. And that was a social worker saying it was finances. So that, you know, obviously that is the situation. And although we're going through all the procedures for the appeals, we seem to be getting nowhere. No one has had any success to date.
Kathy, this seems to me to be a question of you've evaluated need. They've determined that this person needs X provision, and they have unilaterally determined that the criteria should change, and there's no means to facilitate access to that service to comply with the need. That's what it seems to me to be what Rosie's question is about.
Sorry, we were told that actually I was told that my son has never fitted the criteria for the need, for the direct payment need. The Children's Act, 1989 Children's Act, basically, you know, has laid down the criteria, and apparently we've never fitted the criteria, but although I've been having it for 7 years.
I think, Rosie here, that, you know, a few points, but one is if your child is disabled, from what you've said, and meets that criteria, and therefore they would come under, as a child, would come under the Chronically Sick and Disabled Persons Act 1970, which I have talked about before in one of these events, where it very clearly says respite, short breaks, transport, services in the home. So I think, and that trumps the Children Act, Section 17 of the Children Act. So that's an important thing to note. Also, as social workers, for any social worker, any registered social worker, we have a duty to assess as a social worker and not necessarily be directed and sort of squeezing assessment so that we're sort of meeting the needs of a senior manager rather than the needs of the person. And so when a person has needs assessed and there isn't change, you can't suddenly say we've changed our criteria, we're not going to give that service anymore. I know local authorities do that, but if the need hasn't changed, then that service needs to continue, the direct payments, transport, etc. I know there is a wider issue in terms of the economy and money not being available. However, it's a duty of a local authority to meet the needs of people who are eligible for a service under the law, not under their policies. And it is, I don't know if I can say it's unlawful because I'm not a solicitor, but it is not right to change the policies to sort of try and claw back money that's sort of, you know, they haven't got.
David, isn't the answer in that instance judicial review?
In summary, that's probably right. it's interesting that they've withdrawn a service. I was going to say, Rosie, at first, well, they have to reassess before they can do that. But you said they have reassessed. So
Yes.
the first thing I think for someone in that situation is if a service is simply withdrawn, then that's a pretty clear situation in which the local authority can't really do that and does have to carry out an assessment before it makes the decision. And then there's, I mean, the two questions you might then ask. One is, well, have the person's needs changed? Because if they haven't changed, then what's the basis of changing the service? And the other thing is, has the local authority changed its criteria? Because local authorities will generally have their criteria for providing services, and they may have changed the criteria, and that might be a basis for changing decision making and looking at everyone again. If neither the criteria nor the needs have changed, then I suppose the local authority, Rosie, is stuck with saying what they said to you, which is that we've been giving it to him for 7 years and when he should never have had it, which seems unlikely. And the more often they've assessed and the more often they've decided, the less likely it is that that's a sustainable argument. It is difficult to challenge individual social care decisions by way of judicial review, particularly if one is talking about small changes here and there. But it does happen, and we hear from a lot of people, I think, that there's a further round of cuts going in. More authorities are in financial difficulties, effectively an authority world going bankrupt. So there probably will be, I'm afraid, more people facing the challenge you're facing and trying to find ways through of dealing with it. The only other thing I would say, echoing what you said about consider whether there's a judicial review, is that the first tier tribunal can now make recommendations about social care. So there's an argument for
and there's some, but David, as some of the comments, I noticed some of the comments live this afternoon, that the tribunal doesn't have the power to force the council to act in a particular way. It can only make recommendations, or it can only make an order that a plan should be changed in the educational context. But not in this case, in Rosie's case. If it were to make a recommendation, the council ignore it, for example, the route is only to the court, is it not?
It is, but perhaps that's an easier route than directly going to the court just on the change to the... It probably depends a bit where the person is. If they haven't brought an appeal or don't have a basis to appeal, then it's probably best just to look at challenging the decision to cut the service. But if they're in the middle of an appeal, then it might be worth seeking a recommendation, and then that would be another basis for bringing a challenge, potentially at least, both to the cut and to the failure to follow the recommendation.
Rosie, my view is that the broad answer to the question is, it seems to me that a unilateral decision to alter the service or to prevent the means by which you can access the service is something that I would probably want to look at in the context or through the lens of judicial review, probably, because you are identifying provision that you can't realistically access. You know, you're saying there's a need for something, and then you're saying, well, actually, despite the need, we're not going to help you access that service. So that's what would be my first thing that would be sprouting up in my mind. And also, I can see that some people are commenting this afternoon, for example, Charmaine, that legal aid, they can't even find a solicitor to help them take the case. I mean, are we experiencing that? We have so many cases each day, people calling us.
Well, recently, I've attended a school inclusion meeting, and it seems to be the case where we were talking about school exclusion. But apart from that, I think there's a lack of education practitioner out there that were able to facilitate the demand that is coming through the door, like the cases that we are receiving. It just does not kind of match up with the supply and demand. Yeah, it's quite worrying.
Well, Rosie, thank you for joining us this afternoon. If I move on to thank you, Rosie. It's been a pleasure. Thank you for joining us.
Thank you.
Another guest this afternoon has been raised a question regarding certain expectations that have been imposed upon students and parents by an academy school. Basic expectations are listed as: we expect students to follow teacher instructions. We expect students to be as polite to us as we are to them. We expect students to be polite in their facial expressions, tone of voice, body language, and choice of words. We expect students to adhere to SLANT and STEPS at all times. SLANT is an acronym that simply asks students to sit up straight and not slouch. I'm slouching now, aren't I? So I shouldn't be doing that. I'll be in trouble with the school, I think. And you should listen carefully to teacher instructions, ask or answer questions as required, never interrupt when others are speaking, and to track the teacher when they are speaking. So really, these are the kind of impositions that I think Melanie Sakulis, who is, I'm not sure if she's joined us now live, hopefully she has, wants to ask. She says in her question, which gained 35 votes, why are academies able to install blanket policies for all of their students, refuse to make any reasonable adjustments for students with SEND, and despite multiple formal complaints, scrutiny of various organisations, including the local authority, they're able to continue to discriminate without consequence or ramifications? We know that policy doesn't trump the law, but for the academies, they are able to get away with just that. Why is this possible? Melanie, you're with us this afternoon.
Yeah. Hello.
Melanie, how lovely to have you join us.
Hello.
So, did I get your question right? Is that the totality of your question? Or please tell us a little bit about why you ask it.
So we have an academy that one of my children goes to. He has been assessed for ADHD and is currently awaiting a diagnosis. And the academy had a very poor Ofsted report last year. So there was a lot of changes, a lot of new management coming in, and they have installed a very, very stringent and strict behaviour policy. And it's he is being punished for things like chatting in class. So if he gets caught chatting, he gets removed, taken to the isolation room, and he has to sit still. He's not allowed to turn around. And
what? He's not allowed to turn around?
That's one of the rules.
What, you sit in an isolation room? What do you mean by the isolation room? Is this when I did a presentation, Melanie, in Leeds? A number of people asked me questions. In fact, I had one child who sent me a video, which I ultimately decided not to post, mainly because I want to protect the child's anonymity. But that particular child asked me a question: are children allowed to be locked up in a room on their own? Is that what you're saying this school is doing in your case?
So they have a lovely name for it. It's called the recovery room. So it sounds lovely, and they're not in there on their own. As far as I'm aware, it's a big room. There's individual tables and chairs, and they have to sit and they have to put their eyes down and do their work. They can't turn around and look at any other students. They can't mess around or fiddle about. They can't stand up. So it's pretty much sitting down at a table, head down, doing work.
Wow. Chris, what's your initial reaction to Melanie's question?
No, well, thank you for that question, Melanie. Unfortunately, I wish I could say that it's the first time I've heard that type of policy. Sadly, it's not. Same as Tony as well, bringing up with explicit examples of their school, again, with the similar expectations. It is incredibly challenging because, of course, as you say, your child has needs. You said your son has ADHD. So, of course, for him, movement and attention are things that are usually things that he will do spontaneously. He can't really control the manifestation of his needs. So, of course, punishing him, for those could very well be discrimination arising from that disability. And that's prohibited conduct defined by Section 15 of the Equality Act. So, I mean, in terms of pragmatic solution, this goes to Tony's question as well about, well, what can we do pragmatically? And it may be that you've already done these, Melanie, but I'll run them off for people, of course, maybe in the chat as well, because we've got a good discussion going on in the chat about various things. I can
see it going now. So many.
Empathizing with the situation, Melanie, or themselves saying, yes, it sounds like my son or daughter school as well. So, of course, in the first instance, there's a couple of key things within the Equality Act. So, discrimination arising from a disability, I think, is what we're describing there, where the policy in and of itself may be a reasonable one. Okay, you're saying don't fidget, don't disrupt the lesson through talking, etc. But of course, for some children, particularly those with additional needs such as or disabilities, it may be that they are being put at a substantial disadvantage by that. So there's a couple of different things that may apply. It could be firstly indirectly discriminatory. It could, of course, arise from discrimination arising from the disability. And of course, there is also then an obligation to make reasonable adjustments. So we'll focus on discrimination arising from. Obviously, that's where you essentially punish a disabled child, not necessarily because they are disabled, but because something that arises from that disability. So here, they're not saying your son's getting in trouble because he's got ADHD. They're saying he's getting in trouble because he is fidgeting in class, he's turning around, he's disrupting lessons. That's what he's getting punished for. They say we're not punishing him, we're punishing the behavior, but that behavior is inextricably linked to the need. So they have an obligation there to show that the steps that they're taking are a proportionate means to achieve a legitimate aim. So the legitimate aim there would be to keep kind of good order in the class and everyone in a good state for learning. But is it proportionate? I think in the example you gave, well, quite clearly, no. You're taking a young man out of the class for something that's not his fault. You can support him in other ways, maybe by having him supported by, the teacher coming over and trying to redirect him gently to the task, or it, depending on the severity of needs, maybe he will have, a one-to-one or LSA to do that same thing. Those are typical techniques that we would see for children, young people with attention deficit difficulties of various natures. And then in terms of reasonable adjustments, even if the school is saying, well, the policy itself is sound, whether or not the application to your son could put him at a substantial disadvantage, well, that's where the duty to make reasonable adjustments comes into play. This is defined under Section 20 of the Equality Act. And the first requirement of that duty, there's 3 requirements, but the first is what's here, which is where a provision, criterion, or practice puts a disabled person at a substantial disadvantage in comparison with a non-disabled pupil, then essentially to make such adjustments are necessary to essentially avoid that disadvantage. So here, if the school didn't want to go so far as to change the policy overall, they felt that for the majority of pupils it was helpful. But of course, then what should happen is there should be a direction to class staff about your son to say, please do bear in mind that this pupil has ADHD, and it should be something discreet. It shouldn't be something done, announced to the class or anything to embarrass him, of course. It should be something subtly done to teachers so they're aware this pupil has a need that will cause this behavior to manifest. The behavior that we know to manifest from that need should be approached in this different way and should be, non-punitive sanctions applies, say maybe redirection or support or things like that, because otherwise, as you say, he's going to spend more time in isolation, more time out of the class for something he cannot control. So those are really terms of the legal rights. I mean, Melanie, I take it, have you put these points to the school? Have you said to the school that the policy was unfair?
Yes, we have. We actually had a stage 3 complaint meeting with the local board of governors yesterday, and I'm not quite sure what their response will be to that, but yes, we pointed out the law. I was actually told by a senior member of staff at the beginning of year that the academy don't generally make any accommodations for students with ADHD. So yes, that's definitely been our reflection. Now, since we did make a complaint following that, and it has been noticed that they have amended their policy online to include students with ADHD, but they haven't implemented it at all. So it's very much lip service.
Well, first of all, good news. Well done you, for getting the policy at least changed on paper. I appreciate the implementation is different. But again, going on, and again, what's important with disabilities as well is that you don't, strictly speaking, need a diagnosis. You do need a physical or mental impairment, but it's the effect on the child that really matters. But as you say, here we are dealing with that diagnosis. I mean, ultimately, the first tier tribunal does have the jurisdiction to hear discrimination claims, and ultimately, if your case, as well as Tony's case, falls on deaf ears, potentially a claim there is the correct approach. Do bear in mind, and for everyone listening, bear in mind, the time frame for disability discrimination is very short. It's 6 months from the last date of discrimination, the last discriminatory act. So please do make sure that you're acting promptly. You wouldn't want to be out of time. But ultimately, that would be the correct forum. But hopefully, as you say, you had that meeting yesterday, and who knows, maybe the governing body are watching now. Hopefully, maybe some sensible, common sense decision making will be applied. But no, thank you, Melanie, for that
Thank
question.
you.
I hope that's given you some food for thought, at least.
Yes.
Well, and also,
Yes.
Melanie, you asked the question. You say that we know that policy doesn't trump the law, but this academy believes that they can get away with it. Well, the answer to that... Sorry?
Yes, sorry, I know we're not the only family that have had the same issue, and there have been concerns raised by our local parent carer forum, and they are wondering themselves, what can we, if they were to arrange a collective of parents, how can we tackle it? Because we know that the local authority is concerned, but they are limited in what they can do. And it just seems as though they're able to carry on without any ramification from anyone, which is a worry.
Thanks, Melanie. Well, the answer to that is, David, I'm sure you'll be able to say this, agree with me. The academy is subject to the Equality Act in the same way as a mainstream school is. David?
Yes.
And
as I was listening, hi Melanie, as I was listening, about 5 years ago, someone brought a challenge to this, and the academy concerned agreed to review its policy. When I say this, it's the use of isolation, repeated isolation, as a punishment for minor issues of the sort we're talking about now, without adjustment. It didn't get to a hearing. It got sort of basically, it was agreed that there'd be a review of the policy. So there are, general legal issues about repeatedly putting children into isolation, particularly that in cases where it's being done a lot, query how much that child's really getting the curriculum, really getting an education, rather than just being sort of given, sort of worksheets to sit there and do in silence. So they're actually, really are losing out in various ways. Both the disciplinary way and the educational way. So there are ways in which it can be done. Looking at the questions, what struck me is a lot of that is going to depend upon sort of good sense of implementation. And this looking at me in a funny way type discipline has the potential, obviously, to be arbitrary, capricious, unpleasant to be on the wrong end of, and to allow the same person to get pulled up repeatedly for raising their eyebrow type issues, or to avoid sort of minor sarcastic undermining that people don't need. And it's just about needing to be done flexibly and properly and carefully. And as I say, it went to court before, and that school agreed to review its policies. So yeah, it is something that has a legal context.
And Kathy, reading facial expressions, for example, and in this instance, the question was put that we expect students to be polite in their facial expressions. But many children will have a condition such as, I don't know, prosopagnosia, for example, where they will themselves be unable to derive an understanding of another person's facial expression. And their disability might prevent them from being able to demonstrate or compliance with that policy. Would you be concerned about that? Are you not concerned as a disability practitioner? Kathy? She's on mute, is she?
Sorry, I was on mute.
Yeah.
I am concerned because it's a very ableist approach that the school is imposing on everybody. So they're expecting children who with disabilities or who are different to behave like everybody else, and that's not possible. And it's not even about being always possible. It's not possible. and understanding facial expressions, social cues can be really problematic for some children in school. And also, school can be a very stressful environment for young people. Just being there without all these extra expectations imposed on top of just being there is huge. So I feel that this is a very discriminatory approach, and it sort of took me back to thinking about my son, who it doesn't have any additional needs. He's when he was sort of 15, was excluded, sort of stuck in isolation for a week because he was caught vaping in the toilets. And by the second day, he couldn't cope with that anymore. And he doesn't have a disability, but it caused him an inordinate amount of distress. And we had to sort of take him out of school for the rest of the week because he was so upset by it. So I think what's happening is it's wrong. It's serious.
Well, I couldn't cope with it neither. I got to say, I haven't been diagnosed, but I'm probably ADHD. I can't keep still for a moment. If I was locked away in a room, I would really struggle with that. I mean, Emma, for example, Emma Louise wrote as a comment. She says, "My daughter was often left with a chair in a cupboard next to her classroom after having a panic attack." I mean, David, what's going on in the world?
Well, shall I give people the reference and they can Google and look up? Sometimes we sit here and we say, oh, you can do this or that, but just see an example of one that was brought and hit the newspapers. It's in The Guardian in 2019. No, so if you Google Guardian 2019, and the title of the article is Legal Action Prompts Academy to Consider Isolation Unit Criticisms. That's an example of someone bringing a claim about the sort of situation you're broadly talking about, Mike, of being put into isolation. I mean, putting someone in a cupboard sounds like a safeguarding concern in the dark, small, claustrophobic.
No, but David, the point is that one thing I'm finding when I'm going around the country, I did 2 events, well, I've done not more than 2, but the 2 events where this was very, very significant was both in Leeds and in Birmingham, where I learned that some children, I'm not sure whether academies, but certainly a number of schools, have been putting children into rooms and even locking the doors on their own.
Yeah, that does again seem to have safeguarding concerns. That there's no one overseeing the welfare of the child.
Well, it's simply unlawful. You cannot do that. It's child abuse.
There is law about seclusion, used in people when they're seriously mentally ill. There's really clear guidelines and law about how that should be used. So to do that in school and seclude somebody and leave them potentially at risk, it is a serious safeguarding concern.
Melanie, did you find the answer helpful? Sorry, Melanie, you still there? Have we answered your question for you?
Yes, I think so. Thank you very much.
So much for joining us. And just to address Katerina, she says, what about universities? Well, universities are subject to the Equality Act too. And Emma also said, why are academies above the law? I mean, well, they're not, is the short and sweet answer. If I may move on to...
Come in quickly, but Louise Haig as well said about private schools. And again, much like with academies, much like universities, they are also subject to the Equality Act. And again, with independent schools, much like academies, the jurisdiction would lie with the First Aid Tribunal to bring claims against them. So again, that really is the ultimate arbiter, and it can enforce changes of policies and behaviours at the school level.
So if I move on to another question, TF San wrote, and TF San's not with us live now, but the question I think is a right question to put to Kathy. Using FII, fabricating induced illness, against parents to block support if parents go private, threats of removal of children, why does health not follow the FII guidelines, like new social services guidelines for FII, produced by Fiona? Kathy, of course, also commenting on your guidance. So your guidance, it seems, Kathy, is not really helping on the ground, is it? Or it's being ignored, at least.
Yeah, I agree. I think there are local authorities that are following the guidance. It was produced by the British Association of Social Workers. And so some are, many aren't, many don't know about it. And also, if you're thinking about health and education, it is for social workers and they're not following the guidance. And many are working to the Royal College of Paediatrics and Child Health guidance, which is on perplexing presentations and fabricated and induced illness, which has a very rigid approach to offers a very rigid approach to child protection. And then many families are sort of falling into the child protection arena or at risk of their children being removed because it's perceived that they are exaggerating or making up their child's difficulties. There's so much I could say here, Mike, and it'd probably be easier if you just...
No, of course. I mean, just to help, I suppose, Janet Cowden has written on our live now this afternoon. Can we have a link to the FII guidance, please? Kathy, would you mind putting that up on the chat? It might... I'm not sure whether it comes up.
Yeah, I'll do that.
Thank you very much. Well, I mean, FII is, the thing is, what I'm finding, David, is that many parents are not using the social care law to protect their children out of fear that they will ultimately be accused of child abuse or neglect themselves. Primarily, they feel that they have to try and defend their actions and defend their parenting against this over-scrutinising local authority that's being critical about their approach. I really have concern about that, primarily because the working together guidance seems to focus predominantly only on child protection as opposed to looking through the lens of children with disabilities. Do you have anything to say about that, David?
The working together guidance, they do update it quite often, yet structurally, it is a strange thing to do, to bring together what is quite brief guidance on children in need and provision of services for disabled children with quite detailed guidance on child protection. And those two things are only linked in a very limited way, and yet they are there in the same guidance. Which is more useful for one area than the other. Yeah, you would have thought you could produce really good, brief social care guidance and keep that separate from an area where the failures that have been experienced in child protection perhaps need very detailed guidance over hundreds of pages. Linking the two together probably doesn't help either of the areas get the most they could out of the guidance.
Yeah, no, I totally agree. I think that it needs is that there's a really pressing need for the guidance to be exclusively addressing disability, so that parents don't feel this fear. Because I'm finding that more often than not, EHC plans and IDPs, I'm assuming. I don't think IDPs in Wales have to bother with social care as much, do they? They will have that section in Wales. The IDP, the social care. Chris, I'm right on that, aren't I? In Wales, the IDP regime doesn't embrace social care in the same way as it does in England.
It doesn't, no. It has special educational provision that's delivered through health, that's section 2C. And it may refer in section 3, which is a non-enforceable section about other steps that will support the child may have outside of the IDP. But no, formally, the social care provision given to a child does not have a role in the Welsh plan.
So the main point that I'm making is that whenever you look at EHC plans, it's very rare for me to see an EHC plan with anything meaningful coming from social services. Do you ever see it?
Or maybe they are reluctant to include what social workers' recommendations are, maybe due to fundings or other reasons.
Well, who knows? I mean, but it's a real moot point. But moving on, Caroline Bam says, parents of children with SEN and mental health difficulties are being threatened, penalised and criminalised over their children's inability to attend school. Yet the school isn't meeting their needs and there are no alternatives. What does the law actually say about this, and how can the law protect us? David, now you and I have been speaking about this quite recently. about the children who are struggling to attend at school and then their parents are being prosecuted?
Yeah, I mean, there's a duty to consider what the correct provision is for children who are out of school, and to carry out an assessment. And at least arguably, you ought to be carrying out those steps before bringing a prosecution. And I know, Mike, you've written and thought about that quite a lot, that combined, that idea that before bringing a prosecution, there are steps that should be taken for safeguarding and social welfare as part of deciding that the child isn't being sent to the breach of the legal requirement to send the child to school.
Yeah, I think that I actually believe that the unlawfulness is so rife in this area that we're seeing many parents unfairly, absolutely unreasonably, being hurled before the criminal courts in circumstances where they should never be anywhere near them, because the local authority have not done their basic duties properly, carried out their basic duties correctly. So the law does protect. It's unfortunately, not everyone knows how to use it, is the truth. And I think we're seeing an injustice of the kind that far exceeds the situation that we've seen in Bates and the post office. Far. I think I understand there's around 17,000, I may be wrong on this, I don't think I am, but about 17,000 people every month are being prosecuted for, I think it was 17,000 a year actually, people being prosecuted for not sending their children to school. And do you know what my guess is? That around at least half of them, maybe more, should never have been found guilty. That's my view.
Yeah.
Moving on, one of the big questions now, and the long-term implications. I mean, it's going to be on an Education Magazine show that's kind of come up. But Michelle Flynn writes, "What are the long-term implications of the Safety Valve Initiative, and is this initiative even legal?" Now, just for the viewers to understand, the Safety Valve Initiative is an initiative introduced by central government to assist local authorities who have deficit budgets achieve extra funding in return for them committing to reducing the SEN need in their areas. And that would include removing children from the independent sector, repatriating them back into the mainstream sector, and reducing the number of children who might hold education healthcare plans. My view on that is, quite succinctly, I think the Safety Valve Initiative is probably the most serious attack on children with special needs that I have seen in many years, because it is being allowed to go through. And contracts are being entered into between local authority and central government, with the repercussion being that children are having their needs, or they're more likely to have their needs more ignored, and children being who are, in my view, wholly inappropriate for education among mainstream peers because they can't cope with mainstream life because of their special educational needs, being forced into unsuitable provision. Chris, we did the Education Magazine show. There's a broadcast that's going to come out shortly on that. We're going to be talking about this in some detail. But in a nutshell, what's your thoughts on the Safety Valve scheme?
Yes, you're right, Mike. I think that people, should tune into that dedicated episode, a bit like with the FII episode that Kathy did as well, which was excellent. There's more detailed episodes. Please do look at the YouTube channel for more in-depth analysis of some of these issues, because they're all so important that it's difficult to squeeze them in the short time that we have. But in terms of the safety valve, I think that it seems to hold local authorities to ransom, really, saying you can have more money if you cut your budget. And the problem is, the language used in the document is all about, increasing the offers made to SEND children, improving support in mainstream to avoid the need for more special school places, increasing local authority maintain special school places, and taking all these strategies really to avoid, for want of a better phrase, the need to go into the independent sector or to out of county residential placements, try to support more children in county, which are all laudable aims. But the problem is when you then come to the strategy used by the government to say, we've got to do this within 3 years, well, that's not achievable. It's simply not possible to build that infrastructure after 10 years of underfunding in that shorter space of time. So what ends up happening is the only way that you can, cut in time to stay within that agreement is to unlawfully decline or cease either applications for EHCPs or existing EHCPs, or changing plans, again, as we've heard earlier in other circumstances, to cut costs. And that is simply unlawful. What I would reassure everybody watching here today is that the law itself hasn't changed. So the local authorities do have an obligation to still meet the legal criteria that we have discussed. Unfortunately, and I think this really is why we're getting so many of these questions here today and across all of our social media channels and in our cases, is that this financial pressure is only increasing the number of unlawful decisions and increasing the delays even where lawful decisions are ultimately made, because they're just so desperate to avoid that cost for as long as possible, that it really does mean it's just a deeply unpleasant system for all. So I think it's a disgraceful system. I think that the government is reaping what it's sown from chronic underfunding of local authority infrastructure for the last decade or more, and really there needs to be a kind of systemic change at the policy level to really build this infrastructure back up, because that's the only way you're really going to support these children.
David, you and I have spoken about this too, and I mentioned that in my letter to the Secretary of State, which I had a reply to, by the way, very recently, the reply quite succinctly was saying that we are going to be looking into what you say very carefully. So I'm going to be waiting with bated breath for a more comprehensive response than the one I've got so far. But at least I've got them thinking, and at least I think on behalf of all those who follow me here on Facebook and who comment, maybe we will, with a greater audience, as the audience gets bigger and bigger, have more of a say. But at least we've got something back from the Secretary of State today. So, David, what's your thought about the defiance by the executive of the will of Parliament?
Well, it's a fascinating situation. I mean, it really is a fascinating situation. I suppose the best you can say about it, but also the most worrying thing you can say about it, is that it is a way of trying to deal with the unsustainable financial situation of many local authorities. And the government is providing them with more money and trying at best to come up with ways of improving local services so that people don't need specialist services. But we all know and have seen before that the sad reality is that the improvements in local services don't happen, but the reduction in access to specialist services does happen. So that's the worry, and it shows the underlying background of serious problems of providing services in certain areas. It was interesting that after the first round of austerity, perhaps obvious, but interesting to see data about it, the people who really noticed the austerity, who felt it most keenly, the depth of it and the breadth of it, were people who were disabled. And what we find is that some local authorities are in a similar position again, that they simply have no money. And the safety valve, Mike, that you're very carefully and thoughtfully picked up on, as I say, is partly an attempt to deal with that by improving or demanding improvements to local services, but has come with some apparently unlawful statements that access to specialist services will be cut. That's it. They're going to be cut. And so it's a very important issue. I think you've done really well.
Well, those who follow me here will no doubt see what I said in my letter to the Secretary of State. I posted it, actually, Charmaine, but one thing I found extraordinary was one of the councils, it was Bournemouth, Christchurch and Poole, said in its deficit management plan, it's recorded to be aimed precisely at significantly restricting access to EHCP support. It's extraordinary. Yeah. Kathy, that's what's going on in England at the moment, and I'm afraid, sadly, for another day, undoubtedly, we'll talk about what's going on in Wales, because it's no better there, sadly. Kathy?
Yeah. Listening to what you're saying, what everybody's saying, and I'm thinking the amount of trauma that young people, who are being forced to go to education that doesn't meet their needs is really rife, and it doesn't get taken notice of. And the amount of trauma that families will experience because the needs of their child or children aren't being met educationally. But it's also broader than education, because it is about education, health and social care. And it's not happening. And I'm really concerned about the impact of young people growing up traumatized because their needs aren't being met in the education system, and how that affects them as adults. And and that's not taken into consideration. It is a safeguarding concern. It's actually, the state is causing harm to children.
And you see, as an expert practitioner in social care, the long-term ramifications of that.
Yeah, I do. And I see, and I feel sometimes I sort of allude to this or state it often about the risk to somebody's mental health and ending up in the mental health system, psychiatric system, long term, which is also underfunded and very stretched.
Yeah.
And that needs to be prevented. And from a social work perspective, we have a duty to offer a preventative approach, not wait until somebody's in absolute crisis before any interventions happen. And I actually see families who are in absolute crisis and they still don't get the services that are needed. Something's sort of fundamentally so very, very wrong.
Chris, thanks, Kathy. Chris, I can see, looking on Facebook, because that's why I'm looking down a lot on my phone, the questions and the comments they're enormous. But have you managed to pick out any other questions you think are quite pertinent?
Well, I've been looking through, and it's been a really kind of proactive discussion. Obviously, we've already spoken about the Equality Act queries were there, but I think what I see is the theme really has just been large-scale agreement with the circumstances, of our guests and of the questions that have been asked. I mean, a lot of people saying that their local authority is cutting services. They're using the delaying tactics that have been discussed, needs not being recognized. It is very sadly, I think, a further confirmation of what we already know, that there is wide-scale non-compliance. But yes, I think that really not as many kind of new questions, just more people confirming really what we've been seeing, what we've been saying. And I think what's great is these comments will then stay up for everyone to read after the fact and see that this is a widespread issue. There's been a few people offering calls to action as well, to say, well, what can be done at a wide scale level. And I think that where it is governmental policy, that route is through your MPs. I think we've heard, Mike, haven't we, that there are a few parental groups looking to put up petitions for it to be discussed in Parliament. And of course, Parliament's a great opportunity for opponent politicians to also try to make hay of what is really a national crisis. So there are certainly those avenues as well. But individually, it's very much, as we say, about enforcing the individual rights of each child before them. But I think, Mike, you and I were talking earlier, and I think you said that this is one of the most challenging periods you've seen in your career to date for the rights of children in England and Wales.
I think it is, actually. But it's more so, not so much that we tend to see the cases that we do. We of course will be effective in succeeding in generally. I mean, because we know how to navigate through the rules and to resolve the cases. But my fear is for the many thousands, of people who don't have access to that kind of expertise, and the poor decisions that are going to come off the back of this safety valve scheme that I think will ruin many children's lives. And I completely agree with what Kathy said. The long-term consequences of this are going to be far greater than trying in the short term to do what is needed to protect the interests of these children. David, one of the things that the theme I'm noticing from the comments that are coming through on Facebook, some saying we need lawyers to lead parents to help them through this, and can they take class actions and so on. The point that I put to the Secretary of State in succinct terms was that the Parliament has passed law that requires the local authority to assess the needs of the individual child and to then, if necessary, produce an education plan that will set out what those needs are and the provision required to meet those needs. A policy that seeks to ride roughshod through that, irrespective of the fact that the law is saying that this is how you do it, is pursuit, in my view, of an unlawful purpose. To what extent do you think that the executive can continue to advocate in support of a policy that seeks to curtail legal rights in this way, such that if you spend less, you will get more money? And to what extent can the executive be not held to account for defying the will of Parliament? It's kind of question that has been put to me. It's been presented here on Facebook this afternoon. Have you any thoughts about that?
Well, in a way, they're doing more, Mike, than simply advocating for the policy. They are requiring local authorities, entering into agreements with local authorities that local authorities will, I mean, you read out, restrict access to EHCP support, I think it was.
Yeah.
Was the wording. I mean, there's a real risk with a requirement like that. And I think some of the other wording in some cases has been to move people back to local services, which, as I say, presupposes you put the local services in place first. Otherwise, you're just stopping providing people with a specialist service. I mean, we discussed, and there'll be a question to be decided as going forward about whether that's something best dealt with by way of individual cases where someone says you're wrongly removing my service, or whether you can look at the whole structure. And I understand in some examples the way this is going to implement it has become quite controversial in local politics in those areas, and where local authorities are trying to plan at a group level. I mean, there are cases, quite a few cases, in which the courts have been willing to look at cuts, essentially, and test the cuts against the underlying requirements to implement a service. I mean, oddly enough, perhaps because it's where the cuts fell first, there's been quite a lot of cases about libraries where the law requires there to be a generalised library service, and cuts were made to that, and the courts have looked at what the law requires in terms of a generalised service and how you can go about making changes. And you can look both at the reasoning and rationale behind the process, and also, of course, there is the public sector equality duty. That is a duty in the Equality Act to have due regard to the need, not just to avoid discrimination, but to further equality. So there are ways of challenging group decisions, and some of these are becoming very controversial, and you could see them going to court.
My view is that those that follow me here on Facebook should, through groups, perhaps charities groups, start collecting evidence of the impact that this is having in their area. And once I have a proper reply from the Department for Education, I will be scrutinising that reply in great detail with a view to potentially calling upon those who have put together these case studies to make contact with me with a view to thinking about whether or not we can bring a claim to stop this in its tracks. I think this is a real risk to the rights of children. It's very damaging, and I think it will, as I say, have very long-term consequences. Well, I suppose that's probably all we've got time for this afternoon for the Q&A. I'd like to thank my guests very much for joining us. I know it's been quite good fun listening to all these questions and taxing too, and also heartbreaking. I know you wrote that on your note here this afternoon, Charmaine, that some of the comments were actually heartbreaking. I totally agree with you. But thank you, Charmaine. Thank you for joining us this afternoon. And thank you also to Kathy and to David and to Chris, of course. And, of course, thanks to our guest this afternoon, to Melanie. Thank you so much for joining us this afternoon. And, of course, also to Rosie, who joined us. I'm going to be continuing my talk around the UK, because I promised I would. And I'm thoroughly enjoying meeting you at these talks. I find it always nice to do this kind of thing, but it's even better, I think, to see you in person. I've done talks now in Liverpool, Cheltenham, Birmingham, Leeds, Guildford. I've been to Swansea, and I'm due to go on the 26th of April to Bournemouth, where I will be joined by one of my colleagues who will be answering questions, live questions there. And on the 1st of May, it was originally the 2nd of May, but I'm going to be actually on the first move to the 1st of May. I'm going to be giving a talk in Watford. I'm due also, I believe, to go to the Isle of Wight, I think.
Yeah, that's correct.
In July?
On the 5th of July.
5th of July, there we go. Thanks, Charmaine. 5th of July, I'm on the Isle of Wight. And I think, where else am I going?
The 12th of July will be in the Cardiff office.
Cardiff.
And
That's
then,
a Welsh presentation.
Yeah, and we're looking also to have a talk in Exeter as well in September.
Talk in Exeter in September. Sadly, I've had to cancel the Cambridge event, I think,
Yeah,
which was
that's correct.
originally scheduled for the 11th of April.
Yeah, that's correct. Yeah.
But that'll be up for that'll be all of them I'm doing at the moment for this year. It's quite tiring to do it, but I'm trying to get through as many places as I possibly can. I know many of you have asked me to go to different parts of the country, and I would love to come and join you. I hope we maybe to schedule something for next year. Thank you also, Janet, for saying welcome you to Manchester anytime. I'm very pleased you should say that. And thanks, Bev, for welcoming me to Wrexham. I wish I could come along to everyone. Kent, thanks, Zoe. Anyway, but listen, thank you very much to you all for joining us this afternoon. I hope you found the Q&A helpful. And to answer some of your questions, so yes, I will do another one of these Q&As again, because I think it does help a lot of people. So follow me on Facebook, continue to provide your comments. I do look out for them. Can't answer them all, but I do look out and see what's going on, and hopefully then I'll present another comment in the future about the kind of things that you're asking me to comment upon, and I do tend to do that. So thank you all very much for joining us this afternoon, and I wish you all very well.